Will your foreign divorce be recognized in the United States for U.S. immigration purposes? So in order to determine whether a prior divorce is valid and whether a subsequent marriage is lawful, the law of the state where the subsequent marriage was celebrated will govern whether or not the state will recognize the validity of your foreign divorce. Okay, so if you're applying for a marriage-based green card and you've been divorced and you're currently getting married, let's say to your new wife in Virginia, the Virginia laws will determine whether your prior divorce is valid. Okay, now in most US states, the courts respect the principle of comity, and this simply means that they are going to usually recognize and enforce other countries' laws and judicial decisions. However, this is not a blanket rule. The foreign divorce decree must meet certain conditions for it to be recognized, and each state has what it looks out for to recognize a foreign divorce. But usually they look out for things like jurisdiction. The jurisdiction where the divorce was granted must have had proper authority over the parties of the divorce. Generally, this means that at least one party should have had a genuine connection to the jurisdiction where they sought the divorce, like residency. And so, for example, if both parties to the divorce live in the United States, most states will not recognize a foreign divorce, because the typical question that arises is, why did you not get the divorce from the US since both of you live in the US and you went to your home country to get the divorce? A state like Virginia will, however, recognize divorces from Ghana, even if both parties to the divorce live in the US. But some states will not recognize these foreign divorces. Now, the new law for the state of Virginia concerning Ghanaian divorces that are procured from Ghana, you can find it in the case of Eji versus Mariuka. It's a very interesting case. I'll share more about it in my next video. I hope this helps. All the best. Follow me for more.